Keir Starmer stood with the steady resolve of a seasoned barrister at the lectern in Courtroom 1 of the Supreme Court of the United Kingdom. His tailored charcoal suit a stark contrast against the imposing marble columns of the London chamber. The air was thick with anticipation as all eyes fixed on the Prime Minister, a man known for politics, not courtroom battles. Just moments earlier, Lord Robert Reid, the formidable President of the Supreme Court, renowned for his razor-sharp intellect, had interrupted Starmer's oral argument with a stinging challenge. "I find it hard to believe a politician grasps the nuances of surveillance law given your background," Reid declared, his voice dripping with condescension. A ripple of shock coursed through the packed courtroom. Lord Patrick Hodges' brow furrowed in concern. Lord Philip Sales scribbled furiously. A junior barrister dropped his pen in disbelief, and a seasoned Queen's Counsel whispered to her colleague, "Blimey, he's got nerve." Journalists from BBC News and Sky News scratched their notepads with frenetic energy, capturing every word. But Starmer, who had secretly earned an advanced law degree from the London School of Economics, whilst serving as a Member of Parliament, stood unshaken. Lord Reid, an Oxford-educated titan of the law, who had authored landmark rulings on privacy and security over his 30-year judicial career, was certain he could expose this politician as a legal pretender. Yet Starmer, armed with a groundbreaking privacy argument rooted in original research from the British Library, tracing back to the Magna Carta of 1215, was about to turn this ambush into the most unforgettable oral argument in decades. This was not just a Supreme Court hearing. It was Starmer's chance to prove that brilliance can emerge from the most unexpected quarters, potentially reshaping British constitutional law forever. Before we dive into this gripping legal battle, hit that like button and subscribe for more epic courtroom tales. The tension inside the Supreme Court had been simmering for months, ever since Keir Starmer's name appeared on the docket. 3 months earlier, the Prime Minister had filed an amicus brief in the case of Starmer versus Home Office, challenging the legality of mass surveillance under the Investigatory Powers Act of 2016, often called the Snoopers Charter. This program disproportionately targeted minority communities in places like Brixton and Birmingham, raising alarms about civil liberties. Legal circles initially scoffed, dismissing Starmer's involvement as political posturing. Few knew that he had quietly deepened his legal expertise with a part-time advanced degree from the London School of Economics, studying late into the night whilst juggling his duties as a Member of Parliament. Driven by a lifelong passion for justice, forged during his days as Director of Public Prosecutions from 2008 to 2013, Starmer had sacrificed countless nights to earn his degree, determined to protect the civil liberties he had once sworn to uphold. He kept this pursuit private, wary of the scrutiny it might attract. Lord Robert Reid, aged 67, presided over the court with the unyielding authority of a legal giant. Educated at Oxford, he had risen through the ranks as a distinguished judge, authoring pivotal rulings that shaped modern privacy law, and had led the nation's highest bench for nearly a decade. Known for his incisive questioning and a dry wit that could unsettle even the most seasoned advocates, Reid had a reputation for dismantling weak arguments with piercing hypotheticals. When Starmer was granted 10 minutes to argue in support of the petitioner, a rare honour for an amicus brief, the legal community buzzed with speculation. Most saw it as a publicity stunt to make the court seem accessible, but those who had pored over Starmer's 40-page brief recognized a bombshell, a novel argument about the Human Rights Act of 1998, specifically Article 8, which guarantees the right to privacy, challenging decades of surveillance precedent. A corporate barrister whispered to her colleague in the gallery, "I cannot believe they are letting him speak just because he is the Prime Minister. This is not Westminster. You cannot just recite sound bites and expect to convince the Supreme Court." The stakes were monumental. Starmer versus Home Office centred on the government's mass collection of data from community centres in Brixton, seized under the Snoopers Charter based on vague links to suspected extremism, without charging the owners. If Starmer's argument prevailed, it would rein in the Home Office's surveillance powers, protecting vulnerable communities. If he failed, the programme would expand unchecked, and his legal theories, honed through years of solitary study, would be dismissed as the musings of a political dilettante. Stepping into the Supreme Court as Prime Minister, Starmer risked his political reputation, knowing a misstep could be weaponized by his opponents. The courtroom fell silent as Starmer approached the podium, his movements exuding the quiet confidence of a man accustomed to high-stakes debates. Few, perhaps none, anticipated the depth of his preparation. "My lords and ladies, may it please the court," he began, his voice steady and resonant, filling the chamber without amplification. "The Human Rights Act of 1998, Article 8, guarantees a right to privacy, understood since the Magna Carta of 1215, to require not merely procedural nods, but substantial protection against arbitrary state intrusion." His opening was measured but unremarkable. Lord Reid, who had reviewed Starmer's brief with a critical eye, saw an opportunity to expose what he perceived as a shallow understanding. Whilst justices typically allowed advocates to develop their arguments, Reid broke protocol, interrupting just 40 seconds in. "Whilst I appreciate your interest," he said, his tone laced with disdain, "I find it hard to believe a politician grasps the nuances of surveillance law. Your brief seems to overlook settled doctrine on the Investigatory Powers Act." A murmur swept through the courtroom at the unusually personal challenge. Lord Patrick Hodge shifted uncomfortably. Lady Justice Arden's eyes narrowed with a hint of skepticism, and the gallery buzzed with whispered astonishment. A flicker of doubt crossed Starmer's face as Lord Reid's words echoed. But he steadied himself, drawing on years of quiet determination. Meeting Reid's gaze directly, he replied evenly, "My Lord Reid, I believe my argument aligns with the historical understanding of privacy, as articulated in the case of R. versus Commissioner of Police in 2019. Perhaps we should examine the textual and historical evidence together." He opened a well-worn copy of the Human Rights Act, alongside a stack of original sources he had brought. A rare move for an advocate. The meticulous preparation caught Reid off guard. This was not the surface-level politicking he had expected. What followed was the opening move in a legal chess match that would leave the court and the nation in awe. Realizing his initial dismissal had failed to rattle Starmer, Lord Reid leaned forward, his voice sharp with challenge. "Your brief argues that mass surveillance exceeds historical privacy norms, but you have overlooked R. versus Secretary of State for the Home Department in 2019, where this court upheld broad surveillance powers. The question was a trap, designed to ensnare inexperienced advocates. R. versus Secretary was a landmark case, often misunderstood in its nuances. Without hesitation, Starmer responded, "With respect, my lord, I have not overlooked it. On page 17 of my brief, I addressed Lord Keir's opinion in detail." He flipped precisely to the page without looking. Whilst R. versus Secretary permitted surveillance for national security, it was limited to cases with specific threats. Lord Keir noted that blanket data collection, as in Brixton, stretches beyond that precedent. "I have traced every privacy case from the Magna Carta to 1850, 27 in total, all requiring a substantial connection to crime, not the tenuous links here." The courtroom fell silent, a wave of astonishment rippling through the gallery. Starmer was not just familiar with the case, he had conducted a historical analysis that few scholars had dared to attempt. Lord Philip Sales, often sympathetic to state powers, interjected with a rare edge of curiosity. "That is an interesting historical observation, Mr. Starmer, but how do you account for Big Brother Watch versus UK in 2018, where the European Court upheld bulk surveillance?" Starmer replied, drawing gasps from the gallery, "My Lord Sales, I believe Big Brother Watch was wrongly decided. I am not alone." Lord Carnwath dissented, arguing it undermined Article 8. More importantly, it created a tension in our jurisprudence that this case can resolve. He turned a page in his notes. Since then, R. versus Commissioner of Police recognized privacy limits, and T. versus Secretary of State in 2020 reinforced due process. These cases suggest surveillance must respect constitutional boundaries. The dynamic in the courtroom shifted perceptibly. Justices who had appeared skeptical were now fully engaged, their pens scratching across notepads. Lord Patrick Hodge, known for his reserved demeanour, paid unusually close attention, his gaze fixed on Starmer. Lady Justice Arden joined the fray, her tone carrying a hint of skepticism. "Your historical argument is compelling, Mr. Starmer, but there is a practical concern. Surveillance is a vital tool for MI5. Are you suggesting we eliminate it?" Starmer replied with calm assurance, "Not at all, my Lady Arden. I am suggesting we restore it to its historical boundaries. It remains appropriate for specific threats, but when the state can prosecute individuals and chooses not to, yet still invades their privacy, both due process and Article 8 impose higher burdens. Lord Reed, visibly taken aback by Starmer's command, tried a different tack, his voice now measured but probing. Your brief cites obscure 18th-century texts that most scholars have not discussed. How can we be confident these represent mainstream understanding rather than outliers? The question was designed to expose superficial research, as Reed suspected Starmer might have cherry-picked convenient cases. Starmer smiled slightly, sensing the opportunity he had been waiting for. "I am glad you asked, my lord," he said, his tone steady but charged with conviction. Far from outliers, they show a consistent pattern across jurisdictions. From memory, he outlined the facts and holdings of 8 early British cases, explaining how they demonstrated a narrow understanding of state intrusion. Lady Justice Rose, visibly impressed, interjected with genuine curiosity, "Mr. Starmer, your historical research is remarkable. Did you work with a team of legal historians?" For the first time, a flicker of pride crossed Starmer's face. "No, my lady," he replied. "Whilst I read leading scholars, the primary research, tracing these cases through the British Library archives, I conducted myself during my London School of Economics Studies and since, balancing it with my duties as a Member of Parliament." A buzz ran through the courtroom as the weight of his words sank in. Many were learning for the first time that Starmer's legal credentials were not only genuine but hard-earned through years of solitary dedication. Lord Reed, whose earlier dismissiveness now seemed misplaced, shifted uncomfortably in his seat. Lord Patrick Hodge interjected with a thoughtful tone, "Mr. Starmer, returning to the case, how would your framework apply to the Brixton Community Centre, surveilled in this case?" Starmer turned to him, his voice steady but impassioned. "My Lord Hodge, under the original understanding I have outlined, this surveillance fails on multiple grounds. First, a vague link to extremism by a third party creates a tenuous connection. Second, the government has not proved the centre's owners knew or consented. Third, the intrusion is grossly disproportionate." He paused, then delivered his most powerful point. "Most fundamentally, this mass data collection, funneled into general funds rather than addressing a specific threat, violates the public interest test as the Magna Carta understood it." As Starmer's argument gained momentum, court officers discreetly extended his allotted time, a rare courtesy that signaled the justice's deep engagement. Lord Reed, now fully attentive, realized that far from humiliating Starmer, he had inadvertently given him a platform to showcase extraordinary legal acumen. The stakes had escalated far beyond the initial confrontation, and Starmer was far from finished. The atmosphere in the Supreme Court had transformed entirely. What began as skepticism toward a politician advocate had evolved into a masterclass in constitutional interpretation that held every justice in rapt attention. Starmer's command of case law, history, and legal theory rivaled that of the most seasoned barristers. Lord Reed, recognizing his initial condescension had been not just inappropriate but embarrassingly misplaced, sought to regain professional ground. "Mr. Starmer," he said, his tone now one of cautious respect, "your historical analysis is thorough, but I am still troubled by practical implications. If we accept your framework, existing surveillance programs might be challenged. Have you considered the reliance interests?" It was a legitimate concern, one the court often weighed in doctrinal shifts, but Starmer was ready. "My Lord Reed, I have indeed considered the practical implications carefully," he replied, pulling out a document with detailed statistics. "I have analyzed Home Office surveillance data over the past decade. Approximately 85% of current programs would remain untouched, those tied to specific criminal threats or unclaimed data. The affected 15% are precisely those that offend our legal traditions. Mass surveillance of innocent citizens, often in places like Brixton, based on tenuous links, causing disproportionate harm." Lady Justice Rose, who had been listening intently, spoke up with genuine intrigue. "Mr. Starmer, your brief makes an intriguing textual argument about the interplay between Article 8 and due process that I do not believe any scholar has developed. Could you elaborate?" The question reflected the court's growing respect for Starmer's arguments. "My Lady Rose, thank you," he replied, his voice steady but charged with conviction. "Whilst these rights are often analysed separately, Historical evidence suggests the framers of the Human Rights Act understood privacy holistically. When the state invades personal data without meaningful process, it implicates both. As Lord Reed's questions grew sharper, Starmer reached for a weathered folder, his fingers steady despite the mounting pressure. William Blackstone, in a 1765 letter I uncovered at the British Library, he continued, explicitly connected arbitrary intrusions to due process violations. He removed a photocopy, holding it up for the court to see. The letter, unearthed after hours of solitary research in the British Library's dimly lit archives, was my trump card, a testament to my unyielding commitment. It states that unchecked state power over a citizen's privacy is a double affront to liberty. Lady Justice Rose leaned forward, her eyes wide with intrigue, while Lord Hodge ceased writing, his pen hovering in mid-air. Lord Philip Sales, who rarely spoke during arguments, broke his silence, a rare occurrence that caused reporters to sit forward. "Mr. Starmer, your approach is refreshing," he said with a tone of quiet admiration. "You have shown surveillance has exceeded its historical bounds, but how would you distinguish this from Big Brother Watch? Would you have us overturn it explicitly?" The question touched on the court's stare decisis doctrine. Starmer responded with precision, his voice steady but resolute. "My Lord Sales, whilst I believe Big Brother Watch was incorrectly decided, this court need not overturn it to rule for the petitioners. Big Brother involved specific intelligence threats, maintaining some historical connection. This case involves blanket surveillance with only attenuated links. The court could distinguish these, whilst clarifying that surveillance is constrained by historical practice and Article 8. This nuanced response, balancing institutional concerns with his argument, demonstrated Starmer's sophisticated understanding of judicial dynamics. He was not merely making abstract points, he was offering a doctrinally sound path forward. Lord Reed, now fully engaged with the substance of Starmer's argument rather than his credentials, posed a final question, his tone one of genuine curiosity. "Mr. Starmer, if we accept your framework, what specific test would you have us adopt for evaluating surveillance going forward?" It was the kind of question reserved for the most respected advocates, an invitation to shape the law itself. The crowded courtroom recognized the significance of this shift. Starmer did not hesitate. "My lord," he said, his voice ringing with quiet authority, "I propose a three-part test, rooted in original understanding and consistent with R versus Commissioner of Police and T versus Secretary. First, the state must establish a substantial connection to specific criminal activity, not the tenuous links here. Second, where jurisdiction exists, due process requires either a conviction or clear evidence of the owner's knowledge and consent. Third, the surveillance must satisfy a genuine public interest, addressing a specific threat rather than generating revenue." He concluded with unwavering conviction, "This approach honors our legal text, aligns with historical practice, provides clear guidance to lower courts, and protects Britons from one of the most severe state powers, the invasion of their privacy without cause." As Starmer's allotted time expired, a profound silence enveloped the courtroom. Instead of the customary interruption by Lord Reed announcing the end of his time, the justices sat in stunned contemplation. Several were still taking notes, others leaned back, visibly processing the weight of what they had heard. Finally, Lord Reed spoke, his tone now one of deep respect. "Thank you, Mr. Starmer, your argument has been exceptionally informative." The simple acknowledgement carried a powerful subtext, a recognition that Reed's attempt to humiliate Starmer had backfired spectacularly, revealing a legal mind of remarkable capacity and preparation. As Starmer gathered his materials and returned to his seat, a wave of admiration replaced the earlier skepticism, a silent tribute to a leader reborn as a legal titan. The Home Office's counsel approached the podium, visibly shaken. The dynamic of the case had shifted fundamentally. What began as a routine defense of state power had transformed into an uphill battle against a constitutional framework that resonated with justices across the ideological spectrum. Legal reporters immediately recognized they were witnessing a historic argument, one that might redefine British law whilst challenging assumptions about who belongs in the legal profession's most elite venues. The aftermath of what became known as the Starmer argument reverberated through legal and cultural circles with unprecedented speed. Within hours, law professors were assigning the oral argument transcript to their students, hailing it as a masterclass in constitutional law. Constitutional scholars from across the spectrum weighed in, many expressing awe at the depth of Starmer's analysis. BBC legal correspondent Clive Coleman delivered a succinct assessment on the 6 o'clock news. "I have covered the Supreme Court for over 20 years, and I have never seen anything quite like this." Keir Starmer did not just hold his own against Lord Reid. He delivered what may be the most compelling privacy argument ever presented to the court. The Times ran a front-page story titled, "Starmer's Legal Triumph Shakes the Supreme Court," while The Telegraph praised his scholarly rigor, noting, "The Prime Minister has proven himself a formidable legal mind, challenging the very foundations of state surveillance." The following morning, social media platforms erupted with clips of Starmer citing William Blackstone's letter and reciting early British case law from memory, garnering millions of views. A generation raised on Starmer's political persona discovered a new dimension to their admiration, with hashtags like Starmer Legal Genius and Reid Recants trending across platforms. 3 days after the argument, The Guardian published a feature revealing the untold story of Starmer's legal journey. He had completed his advanced degree at the London School of Economics with distinction, studying nights whilst serving as a Member of Parliament, balancing the demands of politics with his relentless pursuit of legal knowledge. His professors described him as an exceptional student, driven by a passion for civil liberties and privacy rights. Professor Helen Mountfield, who taught Starmer's constitutional law course, shared, "He never wanted special treatment. Most students had no idea who was sitting next to them for weeks. He was just another dedicated scholar, albeit one with an unusually commanding presence." The article revealed that Starmer had funded bursaries for law students from underrepresented backgrounds but requested anonymity, a testament to his commitment to justice beyond his public role. His legal studies, the piece noted, were motivated by a deep-seated desire to reform a system he had seen falter during his time as Director of Public Prosecutions. Legal blogs and podcasts dissected every moment of the oral argument, with particular focus on Lord Reid's initial dismissive comment and how the dynamic had shifted as Starmer's expertise became undeniable. Court watchers noted that Reid had grown increasingly respectful, eventually engaging with Starmer as an intellectual peer rather than an interloper. Joshua Rosenberg on BBC Radio 4 reflected, "What we witnessed was a real-time recalibration of assumptions. Lord Reid expected to find a dilettante and instead discovered a brilliant legal mind. His evolution during those 50 minutes teaches us something profound about preconceptions in our legal profession." The ruling sparked a national conversation on privacy, with debates on BBC Question Time and Sky News, highlighting the public's renewed interest in civil liberties. Grassroots campaigns sprang up in Birmingham, advocating for the protection of community spaces from surveillance, reflecting a growing public demand for privacy rights. The professional legal community's response was equally seismic. The Bar Council invited Starmer to deliver the keynote address at its annual conference, a rare honour for a sitting politician. Law school applications from British youth surged by 35%, with many applicants citing Starmer's example as their inspiration to pursue justice. Starmer himself remained characteristically humble in his public comments. When asked about the argument by a reporter at a Labour event, he said, "The law, like politics, rewards thorough preparation. I am grateful the court gave me the opportunity to present an important privacy argument, and I hope their decision advances justice for all Britons." 6 weeks after the oral argument, the Supreme Court issued its opinion in Starmer v. Home Office in a landmark 6-3 decision, ruling for the petitioners and significantly restricting the government's surveillance powers along lines Starmer had proposed. Lord Reid assigned himself the majority opinion, a move many interpreted as a gracious acknowledgement of his initial misjudgment. He wrote, "After careful consideration of the historical record and legal text, we conclude that mass surveillance, as currently practiced, has expanded far beyond its original boundaries. Whilst surveillance remains a valid tool in appropriate contexts, the Human Rights Act does not permit the state to invade the privacy of innocent citizens based on tenuous connections, particularly where, as here, it affects community centres in Brixton." In a historic move, the opinion directly quoted Starmer's oral argument 4 times, including his 3-part test, which the court largely adopted. A footnote specifically commended counsel for amicus curiae for exceptionally thorough historical research that illuminated founding-era understandings of privacy protections. Lord Philip Sales wrote a concurring opinion calling for a re-examination of surveillance doctrine, while Lady Justice Arden's concurrence highlighted the disproportionate impact on disadvantaged communities, citing statistics Starmer had provided. In a remarkable gesture, Lord Reed added a personal reflection in the final paragraph. This case reminds us that legal wisdom can come from unexpected quarters, and that our system of justice is strengthened when diverse voices and perspectives are fully heard. The court benefited greatly from the thorough advocacy and historical insights provided by all who participated in this important case. The practical impact was swift and far-reaching. Within months, councils across the UK reformed their surveillance policies to comply with the new framework. Data from Brixton community centres was returned to local organisations, and MI5 shifted its focus to surveillance tied to specific convictions, abandoning blanket programmes. For Starmer, the experience marked a new chapter. Whilst continuing as Prime Minister, he founded the Liberty Defence Fund, a non-profit providing legal representation to communities affected by privacy violations, ensuring his legacy would extend beyond politics. Leading law schools, including Oxford and Cambridge, invited him to deliver guest lectures on constitutional history, where he inspired a new generation of legal scholars. 6 months after the decision, Starmer and Lord Reed appeared together at an Oxford Law School forum on civic education. Their discussion, marked by mutual respect and even occasional humour about their initial courtroom clash, demonstrated how adversarial proceedings can foster understanding when conducted with integrity. Lord Reed acknowledged publicly what many had observed privately. Mr. Starmer taught me a valuable lesson that day: never to confuse political office with capability, never to assume unconventional paths to legal knowledge are less valid. His argument in Starmer versus Home Office will be studied by law students for generations to come. Starmer responded with characteristic dignity. The beauty of our legal system, when it functions as intended, is that arguments stand or fall on their merits, not on the identity of those who make them. I am grateful the court was willing to engage seriously with the privacy issues in this case, regardless of the unusual messenger who brought them. The exchange, widely shared across social media and featured in law school orientation materials, became a powerful symbol of how preconceptions can be overcome through preparation, perseverance, and the courage to speak truth to power. In classrooms, courtrooms, and public discourse across Britain, the story of how a Prime Minister humbled the Supreme Court President, not through political clout but through scholarly excellence, became a modern parable about judgment, opportunity, and the ongoing British struggle to create a legal system where ideas truly matter more than identity. The decision inspired a wave of civic engagement, from community-led privacy initiatives in Birmingham to nationwide calls for legislative reform, cementing Starmer's argument as a turning point in the fight for civil liberties. Thank you for watching this remarkable story about Keir Starmer's Supreme Court triumph. If this tale of legal brilliance inspires you, like and subscribe for more. Share your thoughts below.